Okay, let's get started again and talk about securing rights for other groups: Latinos, Asian, Native Americans, disabilities, LGBTQs, disabled groups. Um, in addition to African Americans and women, the number of other groups in the U.S. society do face discrimination. And one of the lingering results can be that a group suffers from below average income. And in Figure 5-1, this shows the percentage of persons with incomes below the poverty line. However, interestingly enough, now you can see that Asians are very similar to Anglos. Now, children, they're more likely than adults to live in poverty, and this makes it more damaging. So let's look at three groups struggling for equal treatment: Latinos, Asians, and American Indians or Native Americans. And then we'll look at disabled, gay men, and lesbians and transgenders. Latinos, the largest ethnic minority now in the United States since I believe, since the 2000 census, they constitute nowadays the largest ethnic minority, but they're not monolithic. They can be of any race: Anglo, Black. Hispanic is just a official U.S. government term used since the 1980 census. As you can see in the countries of origin, figured 5-2, the largest group consists of Mexican Americans, who constitute 63% of the Latino population, actually 64.1%. 19% are other, 9.5% are Puerto Rican, who live mostly in the New York area. Cubans live in the Florida area, and they're mostly conservatives, and they will typically vote for Republican candidates. Mexican American, Puerto Rican identify with Democrats. However, this year um, they might break in greater numbers for the Republican candidate. A problem for the Hispanic community is that many of their members arrive in this country illegally. Demand for the labor of such persons has been high. However, and in fact, most unauthorized immigrants came to the United States to work. Others are small children. Now, many families have members who are U.S. citizens, often children born in this country, while other members are unauthorized. As a result, deporting illegal immigrants can split up families or force U.S. citizens into exile. So, immigration reform is an issue for many Latinos. Now, the Republican Party in the last 3 years has taken a stand against reform that would let unauthorized immigrants regularize their status. Donald Trump's hostility towards illegal immigration has been one of his strongest positions, but he's gained with Hispanics. Um, and in this election, he may be polling 40% in some areas of the country. Now, generally, Latinos in the United States have low levels of political participation. I have included some right wing Latinos of Miami, the Proud Boys. They came out in the debate. They're not so much a racist group. You can watch a video on them and make your own determination. Uh, they group that looked at this also looked at liberal Latinos, and they debate conservative Latinos on immigration, Trump, and racial identity. You can see how they stand on these issues. In Texas, 30 of the 150 in the House are Hispanic, And in the Senate, 6 of 31 are Hispanic. Educated, higher socioeconomic Hispanics do tend to split their vote between the Republican and Democratic Party. And the Trump train did come to Laredo, and about 4,000 people participated in that event. Now, Asian Americans have been excluded in the Chinese Exclusion Act of 1882. They were prevented from coming into the United States to prospect for gold or to work in factories or on the railroads. And in 1900, immigration continued to be restricted. They also could not attend schools with white children, and after the bombing of Pearl Harbor, they were excluded from certain areas of the West Coast and interred during the Second World War. Now, in the 80s, Congress provided money to compensate former camp inhabitants. Now, native tribes, they were considered as foreign nations in 1789 by the Congress. So they had no voting rights act, no voting until the 1920s, when the 14th Amendment was interpreted to give them citizenship rights. Right now we have several agencies: the BIA, the Bureau of Indian Affairs. Another agency handles education. In the late 1880s, the policies of the administrations were to assimilate American Indians into the mainstream culture. Many reservations were reduced in size. Right now, tribes are scattered, small, and their political power is fragmented. Most live off the reservations. Now, unfortunately, they don't really control their own land, many of the Indians.
We've all heard about how many bad things the U.S. government did to American Indians in the past. But what about today? Like most people, the only time I hear about today's American Indians is when people are outraged about sports mascots or team names, like the Washington Redskins. But sports teams' names are the least of Indians' problems. Did you know that Indians have the highest rate of poverty of any racial group in America? Did you know that alcoholism is more common among Indian youths than among youths in any other ethnic group? Did you know that the rate of child abuse among Indians is twice as high as the national average? Until I visited Indian reservations for my book, The New Trail of Tears, I didn't know any of this. What was at the root of these terrible problems, I wondered? And the deeper I dug, the more I realized that between the 19th century and today, nothing has changed. It's still the government. The two main agencies that oversee the activities of Indians who live on reservations are the Bureau of Indian Affairs, or BIA, and the Bureau of Indian Education, or BIE. Education, economic development, tribal courts, road maintenance, agriculture, and social services. The federal government basically funds and controls all of it. It's no wonder Indians say BIA stands for Bossing Indians Around. Together, these two agencies have combined budgets of $3 billion per year and have 9,000 employees. That's one employee for every 111 Indians on a reservation. Of that $3 billion per year, the BIE uses $850 million of it to educate 42,000 students. That's more than $20,000 per student, compared to a national average of $12,400 per student. Plenty of other federal agencies also have programs for Indians. For instance, the Indian Health Service had a 2015 budget of over $4.6 billion And yet there are widespread and documented reports of nurses being unable to administer basic drugs, of broken resuscitation equipment, and of unsanitary medical facilities. Obviously, inadequate funding isn't the problem. The billions of dollars that the federal government spends on Indians every year hasn't made their lives better. In fact, by most measures of economic and social health, the lives of American Indians are only getting worse. Aside from issues of culture, the only way out of this morass is economic growth. But the reservation system makes this almost impossible. Following a series of treaties and laws over many decades, some well-intentioned, some not, the federal government decided to hold Indian land, quote, in trust in order to prevent non-Indians from ever buying that land. But other than Indians, the only people who have things held in trust for them are children and the mentally incompetent. Can anything better illustrate the low regard the government has for American Indians? The awful consequence of this land trust is that Indians can't sell their land, which means they can't use it the same way other Americans do. For example, as collateral to get a loan to start a business. What bank would lend to landowners who don't own their land? The other effect of this absurdity is that Indians can't develop this land that they don't own. Indian reservations contain almost 30% of the nation's coal reserves west of the Mississippi, 50% of potential uranium reserves, and 20% of known oil and gas reserves. Those resources are estimated to be worth nearly $1.5 trillion. But the vast majority of Indian lands with natural resources remain undeveloped because of federal regulations. For instance, for Indians to get permission to mine for coal on Indian land requires 49 steps spanning 4 federal agencies. Each of these 49 steps can take months or years to be approved. There are so many government regulations that just to apply for a permit to dig a hole costs $6,500. Is it really any wonder that this community is mired in poverty? So what can be done? For starters, end the trust system. Let Indians do what they want with the land they own. Get the massive federal bureaucracy out of the way. Give American Indians the opportunity to embrace the same thing that has lifted millions of other people out of poverty and into the middle class: free enterprise. It won't happen overnight, and it won't be easy, but it will do a lot more for American Indians than changing the name of the Washington Redskins. I'm Naomi Schaefer Riley for Prager University.
Now, the Rehabilitation Act of 1973 set in motion a lot of laws passed by Congress to prohibit discrimination against persons with disabilities in programs that receive federal aid. Another one passed in the 70s said that public schools have to provide free, appropriate, and individualized education in the least restrictive environment for disabled children. But the really huge one that I have a distinct memory of myself is the one in the 1990s, the American with Disabilities Act. This one had a transformative effect on physical buildings and public services. They must be accessible to persons with disabilities, and employers must reasonably accommodate the needs of workers or job applicants with disabilities who are otherwise qualified for particular jobs, unless to do so would cause the employer to suffer an undue hardship. And the ADA defines persons with disabilities as persons who are physical or mentally impaired and substantially limits their everyday activities. Now, health conditions that have been considered disabilities under federal law include blindness, history of alcoholism, heart disease, cancer, muscular dystrophy, cerebral palsy, paraplegia, diabetes, and acquired immune deficiency syndrome. Now, the ADA does not require employers to hire or retain workers who may pose a direct threat to the health and safety of their co-workers. Now, beginning in the 1999 session till 2002, the courts handed down a series of cases that substantially limited the scope of the ADA at the request of businesses. And the court found that any limitations that could be remedied by medication or by corrective devices did not qualify as a protected disability. But in '08, the Amendment Act of 2008 overturned most of these limits. Now, here's a list of some of the key ones that you should know. The Civil Rights Act of '64, that bars discrimination in employment on all those things. The Voting Rights Act, the Fair Housing Act, Title IX, the Rehabilitation, and the American with Disabilities Act, and some amendments. Now, today, many Americans, including 7 members of Congress, are openly gay, lesbian, or bisexual, but until the '60s, gay men and lesbians tended to keep quiet about their sexual orientation until a '69 incident in which people in the Greenwich Village started rioting at a Stonewall Inn, a popular gay bar. So in June of that year, the bar's patrons threw beers and bottles at the police, and this led to the Stonewall riot and launched the gay power movement. And by 2003, the Supreme Court had ruled that sodomy laws or laws against sodomy were invalidated. So you have a 14th Amendment right to sodomize each other. And this allowed further extension of LGBTQQ type rights. There were states that outlawed gay marriage, and now we have states that are specifically prohibiting discrimination in employment based on sexual orientation. The big case that resulted in the huge changing legal landscape was the Obergefell case.
The day after the United States Supreme Court decided Obergefell versus Hodges, same-sex couples all over the United States celebrated the decision by exercising their newfound constitutional right to apply for a marriage license. In a bitterly divided ruling, the court held that the United States Constitution prohibits states from denying same-sex couples the right to marry. James Obergefell and his partner John wanted to get married after John became terminally ill. At the time, they were living in Ohio, a state that banned same-sex marriage. So the couple wed in Maryland, where same-sex marriage was recognized. When John passed away, Ohio upheld its same-sex marriage ban and refused to list James as John's surviving spouse on the death certificate. Obergefell, plus 13 others affected by the same-sex marriage bans, sued the state officials responsible for enforcing the ban. The couples argued that denying them marriage rights violated the 14th Amendment. In each of the separate suits, the district courts agreed with the couples and found that the state's bans violated the 14th Amendment. The Court of Appeals for the Sixth Circuit consolidated the 14 cases and reversed, holding that the Constitution doesn't require a state to recognize same-sex marriages from other states. The Supreme Court granted a consolidated petition for cert. There were 2 questions before the court. First, are states required under the 14th Amendment to issue marriage licenses to same-sex couples? Second, are states also required to recognize lawful out-of-state marriages of same-sex couples? The court answered both questions in the affirmative and held that same-sex couples have a constitutional right to marry under the 14th Amendment. Further, the court held that the marriage right must be recognized across states. Justice Kennedy, writing for the 5-justice majority, reasoned that the right to marry is a fundamental right protected by the Due Process Clause. For support, Kennedy cited precedent. For example, in the 1967 decision of Loving versus Virginia, the court invalidated a ban on interracial marriages. 11 years later, the court in Zablocki versus Redhill struck down a marriage ban for fathers who were delinquent on child support payments. Additionally, Kennedy noted that judicial precedent had progressed toward greater recognition of rights for same-sex couples. For example, in the 2003 decision of Lawrence versus Texas, the court invalidated laws that criminalized homosexual acts, holding that same-sex couples have an equal right to intimate association. Additionally, Kennedy cited 4 principles and traditions behind the constitutional protection of the right to marry. Each of these traditions applies equally to same-sex and opposite-sex couples. First, the right to choose whether and whom to marry is inherent in individual autonomy. Second, the right protects the intimate relationship between 2 people. Third, the right protects children and families by giving legal protection to home building and child rearing. And fourth, marriage is the very keystone of the social order and the foundation of the family unit. The deep social importance of marriage is evidenced by the government's provision of numerous benefits to opposite-sex couples, including tax benefits, inheritance rules, evidentiary privileges, and medical decision-making authority. In reaching his conclusion, Kennedy also relied on the Equal Protection Clause of the 14th Amendment. For Kennedy, due process and equal protection were interrelated when it came to the marriage right. He reasoned that the marriage bans denied same-sex couples the same government benefits that opposite-sex couples enjoy. This denial was particularly significant from a constitutional perspective, given the long history of animus towards same-sex relationships. The court reversed the Court of Appeals and held that states must issue marriage licenses to same-sex couples and also must recognize lawful out-of-state marriages between same-sex couples. 4 justices dissented. Chief Justice Roberts began by arguing that the states should be free to say what counts as marriage because the Constitution doesn't define marriage. Roberts further noted that by substituting its own judgment for state legislatures, the majority usurped the right of the people to redefine marriage through the democratic process. Additionally, Roberts warned that if the majority's reasoning is correct, then polygamous relationships should also be entitled to constitutional protection. Justice Alito wrote a separate dissent to argue that because the Constitution is silent on same-sex marriage, the issue is reserved solely for the states. Justice Thomas, in a separate dissent, noted that the majority opinion distorts the doctrine of due process. For Thomas, the Due Process Clause guarantees only the process that is due before someone is deprived of life, liberty, or property. Thomas argued that the Due Process Clause doesn't provide a basis for creating new substantive rights, and that the majority's reading dangerously stretches the constitutional text. Justice Scalia wrote a colorful, bitter dissent. According to Scalia, the majority took on a judicial policymaking role by resorting to pretentious content and, quote, straining to be memorable passages, unquote. For Scalia, the majority opinion was a, quote, threat to American democracy, unquote. Obergefell versus Hodges is the first Supreme Court case to conclude that the constitutional right to marry extends to same-sex couples. The decision was celebrated as a breakthrough ruling that advances equality for same-sex couples, but also criticized as an overstep of judicial authority.
Now, gay men can also, and women can also serve openly in the military as a gay man or a gay woman, a lesbian. Now, transgenders these people that are male or female, but sense that they're the opposite, well, they're called transgenders. Some go an extra step and have surgery. Some do not, but states do not allow people of different sexes to go into opposite bathrooms, those kinds of things. And that's where many issues are fought out in the state courts. The Obama administration threatened to withhold money if states didn't allow people of different genders to go in other gender bathrooms. Now, the Trumps have reversed this Obama policy. But the issue remains controversial and people protested. Now let's go beyond equal protection and talk about affirmative action, why it's controversial. But beginning in the 60s, an idea developed that what government could do to hasten equality and civil rights is to legislate that promotes equal opportunity. So what the federal government, through its available state implemented programs, encouraged the hiring and promotion of individuals who had been traditionally discriminated in the past. So what we'll do is we'll take positive steps to remedy past discrimination. And this policy took off during the Johnson administration of the 60s. And this will also include college admissions, where members of groups that had been not allowed to enter colleges in the past, they will be promoted, they'll be looked to gain entry into their programs. Now, this policy didn't go unnoticed by many, and it was tested in a case, Regents of California versus Bakke, in which a man by the name of Bakke, as you can see, you'll see in the landmark cases, he tested whether this was not a case of reverse discrimination, because the university system was using a quota system. They were setting aside or reserving a specific number of seats in a law school, or I'm sorry, medical school, for minority applicants. And he felt that this violated the equal protection. For him, he was white, but it applies to whites and blacks, the Equal Opportunity Clause of the 14th Amendment. And the courts concluded that although both the Constitution and the Civil Rights Act allow race to be used as a factor in making admissions, race cannot be the sole factor. So because the university's quota system was based solely on race, it was unconstitutional. Now, in 1995, another case, Adarand versus Pena, this was a big landmark decision in which the court held that federal, state, and local affirmative action programs that use racial classifications as the basis for making decisions are subject to strict scrutiny. So they've got to show there is a compelling interest and it's narrowly tailored to meet past discrimination. Cannot make quotas. Affirmative action programs cannot use preferences, cannot be maintained simply to remedy past discrimination. They've got to be used concurrent with the discrimination, should it be happening. And since that, there have been several lower courts that have raised the question of whether affirmative action programs are designed to achieve diversity on college campuses and whether they are constitutional or not. One of those was a case out of a couple cases out of Michigan. Let's take a look at these. Here's one, I believe it's called the Grutter case, Grutter versus Bollinger.
Grutter wanted a career change. She probably never dreamed that it would lead to a showdown with the University of Michigan Law School before the United States Supreme Court. Grutter was a successful business owner when she decided to try law school. But when Michigan denied her application, it thrust her to the forefront of the national debate over affirmative action. Grutter applied to the University of Michigan Law School, a highly competitive and elite institution, in 1997. Despite her academic qualifications, including a 3.8 undergraduate GPA and 89th percentile LSAT score, she was first waitlisted and then ultimately denied a spot. Grutter filed suit, claiming the law school's denial of her application amounted to racial discrimination. Michigan's policy of considering each applicant's race during the admissions process, Grutter argued, had the effect of giving minority applicants a leg up on equally qualified white applicants, which violated the 14th Amendment's Equal Protection Clause. The district court determined that the school's consideration of race in admissions was unconstitutional, but the Court of Appeals reversed. The Supreme Court granted cert. The issue was whether, consistent with the Due Process Clause, a public school may consider race as a factor in the admissions process. The court answered yes, holding that institutions of higher education may consider race as one factor among many in their admission schemes in an effort to reap the educational benefits that accompany a diverse student body. In a 5-4 decision, Justice O'Connor applied strict scrutiny. To survive strict scrutiny, the school had to identify a compelling interest in its consideration of race, and then show that the policy was narrowly tailored to further that interest. O'Connor affirmed the view espoused by Justice Powell in an earlier case, Regents of the University of California versus Bakke, that institutions of higher education have a compelling interest in cultivating racial diversity. Acknowledging the importance of academic freedom, the court deferred to the school's assertion that diversity added significantly to the quality and value of its legal education program by encouraging an increased cross-racial understanding, a broader worldview, and more vigorous in-class debate. The court further held that the school's admissions policy was narrowly tailored to achieve diversity. In so doing, the court distinguished Bakke. In Bakke, the court rejected as unconstitutional an affirmative action plan that reserved 16 out of 100 seats for minority students. In contrast, Michigan's plan didn't establish a quota. Rather, it sought to admit only an undefined critical mass of diverse students. To fulfill this vague objective, the school considered race as simply a plus factor. In other words, race was one factor out of many that could ultimately bear on the admission decision. Unlike the fixed quota system rejected in Bakke, Michigan's admissions process considered the unique qualifications and experiences of each individual applicant and thoroughly considered the various ways that an individual student might contribute to on-campus diversity. Accordingly, the court upheld the school's admission program and affirmed the decision of the Court of Appeals. Justice Ginsburg concurred to note that using race-based classifications in admissions plans is not a solution that can be used indefinitely. However, Ginsburg emphasized that at the time the case was decided, such classifications were necessary and showed little sign of impending retirement. Justice Thomas concurred in part and dissented in part. In an opinion highly critical of the majority's depiction of Michigan's educational interest in racial diversity, Thomas suggested that the school's real interest amounted to nothing more than protecting the prestige and elite status of the law school. Thomas suggested that the school must choose, either maintain the caliber of students admitted with a race-neutral program at the expense of minority enrollment, or lower the applicable admission standards for the sake of diversity. The school may not constitutionally have it both ways. Chief Justice Rehnquist's dissent took aim at the concept of critical mass. Rehnquist pointed out that while Michigan avoided attaching any numeric threshold for what constituted critical mass, there was a disparity in how that term was applied across different minority groups. Instead of admitting roughly the same number of students from each underrepresented group, African American students were consistently admitted at a higher rate than Hispanic or Native American students. Rehnquist thus viewed the school's policy as a covert means of social engineering, rather than a way to seek the educational benefits of true diversity. Following Bakke, Grutter was the next step in the evolution of the court's affirmative action jurisprudence, finally confirming what had been left undecided by Bakke.
Now, the Fisher case recently decided the courts, interestingly enough, first they sent it to the lower courts for further argument, but then when they finally heard it, they found that the diversity policy that University of Texas used was sufficient, and that they proved to the court that their policies were narrowly tailored to reach a goal as the law requires. So that's basically the position of the courts in all these affirmative action is to take a look at each one that happens to come to the court and determine uh, what they should do. But as Ginsburg said, the justice who recently died, um, these are temporary, but we'll see how temporary they are. Maybe in the next few years, the court will strike down these university affirmative action admissions programs. Now, states have taken the ballot initiative process to sometimes ban. The biggest state, California, did. I think back in the 90s, and they're going to try to reverse that this year. We'll see how that plays out. Michigan, they banned affirmative action in that state just 3 years after the Supreme Court decision in Grutter. And in 2012, a federal court overturned the voter approved ban, but in 2014, the Supreme Court reversed the appeals court and said the state voters have the right to eliminate affirmative action programs. So states can ban affirmative action programs. They can eliminate them. Now, some states, in the meantime, have tried to develop what we call race-blind ways to attract minority students, like Texas. We've established a program in which the top students of every high school are guaranteed admission to UT. Originally, it was top 10%. So this guarantees top students at minority-dominated inner schools can attend state-supported public university. And white students from rural, often poor communities. Now, the losers would be the upscale metropolitan neighborhoods or suburbs, and they have high test scores, but they're not in the top students of their schools. So one result is that more students with high test scores enroll in less famous schools, such as Texas Tech or University of Texas at Dallas. All righty. Well, if we go back to the other groups, we can see that the largest ethnic minority group now has their own problems. Now, they don't participate as much as other groups, but they do tend to vote. Mexican Americans, Puerto Ricans tend to identify with the Democrat Party. Cubans tend to identify with the Republican Party. And the immigration issue is kind of a political football. And both parties, though, like the lower labor costs with increased immigration. And you can see two groups of Latinos debate these issues in those YouTube videos, and you can watch them on your own time. But I do suggest them both. The Proud Boys have been the focus of some attention, and you can determine whether they're racist groups or not. Now, Latinos have low levels of political participation. They hold lots of offices in Texas. You can see that. Asian Americans, they represent a highly skilled immigrant group. They've suffered discrimination. Native tribes were designated as foreign nations and were controlled by the BIA still till today. But in the 1880s, policies such as assimilation occurred and reductions in reservations. And activism is low right now because of scattered small tribes and many living off the reservations. There have been laws passed in the last 30, 40 years, like declaring the American Indian language as unique. Courts have now recognized Native American treaty rights, and there's been an Indian Gaming Regulatory Act to allow American Indians to have gambling operations, but those are tightly controlled by the tribal councils, and it hasn't alleviated much poverty. As the lady suggested in the video, there might be other ways to do that. Disabled people have received a lot of federal protection since the 70s, especially in the 90s with the ADA. And gay men, lesbians, also since the Lawrence versus Texas eliminated anti-sodomy laws, and the Obergefell case, which the courts ruled gave everybody the right to same-sex marriage. Military, you can serve openly now, and transgenders still are on the receiving end of some discrimination. Affirmative action was an effort beginning in the 60s to socially engineer society, much like busing, where you force things to happen. And that's led to a lot of Supreme Court cases like reverse discrimination, quota systems. And the courts have got involved and said, well, we're going to look at these very strictly, scrutinize them, and if they're not going after a specific law, then they got to be struck down. Now in Grutter, Michigan showed this was legitimate, and in Fisher, they also showed that these two were legitimate admissions policies, but states have started to outlaw affirmative action programs, and the courts have upheld that effort. So that will conclude today's presentation, and we'll take up chapter 6. Good luck with the exam. Study the PowerPoints and the fill in the blank multiple choices at the back of each chapter, 4 and 5, for the second quiz, and study the review. And it'll be open until next Saturday. That'll be the 17th of October. And we'll get into chapter 6, 7, and 8. We'll go rather quickly. Thank you for your attention.